And then is Rebecca Risner here? All right, come on up here, ma'am. (75C01 2503 CM1). State of Indiana versus Rebecca Risner. That's you, ma'am, right?
Yes, Your Honor.
So do you understand your rights in your criminal case?
Yes.
Do you have any questions about them?
No.
Okay. I'm going to assume, just from looking at this case, that you never bonded out. Is that correct?
No, I was never given a ticket or charged or that.
Well, you've been charged. That's why you're here, but you never had to post a bond in city court. Is that correct?
No.
Person had to play that.
Okay. And so you understand your rights, and I've been given the impression from the filings in the case that you intend to represent yourself. Is that correct?
Yes, Your Honor.
Okay. So I have to read an advisement to you that the Indiana Supreme Court wants me to read, and that's what I'm getting ready to do. Have you been read this advisement before?
No.
Okay. So here we go. Someone have you state your full name for the record, man.
Rebecca Risner.
Are you under the influence of any alcohol, drugs, medications that could affect your ability to understand what we're doing today?
No, Your Honor.
Do you understand your rights?
Yes, Your Honor.
So, you already have a trial date. All right. Most likely today, we're going to set a trial date for you. And you need to understand that you've indicated to me that you want to represent yourself. And that ultimately means representing yourself pre-trial, but it also means representing yourself at a trial.
Mm-hmm.
And you have a right to represent yourself at trial, just as you have a right to have counsel represent you and have the court appoint counsel for trial and for pretrial matters if you cannot afford an attorney. Before you make the final decision to represent yourself, I want you to understand what you're going to be giving up. You may have any number of defenses which apply to your case, which an attorney is trained to know. Should you be convicted of the offense, you're facing a penalty of probably, is it a B?
Yeah.
180 days in the county jail. So do you understand that the absolute worst thing that could happen to you is you spend 6 months in jail, you get day for day credit, so that'd be 3 months real time. Do you understand that?
Yes, Your Honor.
At the sentencing in this case, there are factors that the court could consider if you were convicted in increasing or decreasing the sentence within the range that's enumerated in the statute. These are factors that an attorney would know about. An attorney has developed certain skills to assist you in presenting a defense to the charge against you. These include investigating your case, interrogating witnesses against you, finding favorable witnesses or obtaining their testimony, explaining charges and any lesser included offenses, gathering documents or other kinds of written evidence, preparing and filing motions before trial, such as motions for speedy trial, motions for discovery, or motions to keep out unfavorable information from being received as evidence, examining and cross-examining witnesses at trial, recognizing objectionable and unfavorable evidence, and promptly objecting to its use, presenting favorable sentencing information and attacking unfavorable sentencing information in jury trials, presenting favorable opening and closing statements, preparing appropriate written jury instructions, and the process of selecting a jury, and the training, knowledge, and skill of properly preserving the record of the case for the purposes of appeal. An attorney can also evaluate the strengths and weaknesses of the case against you, give you expert advice on whether you should attempt to seek a plea agreement with the state of Indiana, which may result in the dismissal of some of the charges or a recommendation for favorable sentence in return for a plea of guilty. You must also understand that if you decide not to have an attorney, you will not receive any special treatment with your defense. You will have to follow all the same rules and procedures in your case as an attorney would have to do. So just so you understand less formally, what they want me to make clear to you is that once we start doing this, if you're going to say, well, I didn't know that, that doesn't matter, right? So you have the same rules as an attorney would have. The state will be represented by an attorney and will have the advantage an attorney represents. If you decide to represent yourself and the result turns out badly, meaning you're convicted and sentenced, you need to know that you will not be able to complain that you were not an effective attorney in your own defense. In other words, you can't represent yourself and then say you didn't do a good job at it. As I've told you, you have a right to decide against having an attorney, but you must be aware that deciding not to have an attorney can turn out to be a very bad decision. Experienced lawyers almost always decide to be represented by another lawyer in a criminal case. In fact, among lawyers, there's a saying that if you represent yourself, you have a fool for a client. There are some things that you should consider before you appear at trial with an attorney, and I want to ask you about them now. What knowledge and skills do you have that would be helpful for you if you represent yourself?
I just do a lot of research and a lot of reading,
Have you ever studied criminal law?
very little,
Have you had any previous experience with the criminal justice system?
no,
Have you ever participated in a jury trial before?
I have,
As a defendant?
no, as part of a plaintiff.
So like an attorney represented you?
I was a state's witness,
Okay, so you testified.
yeah,
Okay. Do you understand that that's different than
Right.
actually running the trial, right?
right.
Okay. How much education have you had?
Yeah. Some college,
Okay. And I would assume you're able to read and write well,
yes,
and you're a good public speaker.
sure,
I guess we'll find out, right?
yeah,
Can you quickly become familiar with large numbers of special rules and procedures and use them in the right way in a high pressure situation such as your own trial?
yes,
Okay. Have there been any promises or suggestions from anyone that you'll receive special treatment or a milder sentence if you do not have an attorney?
no,
Has anyone said or implied that you or anyone you love or know will be harmed or disadvantaged in any way if you have an attorney?
no,
Do you have any questions about anything I've asked you?
no,
And you still wish to go forward without an attorney?
yes,
Okay. Okay, so I'll just kind of let you do what you want to do here. So I would assume you want to be heard on your motions first, right?
whatever the court decides.
Well, no, so
Sure,
you
yeah.
tell me what you want to do.
I would like to be heard on my motions. However, I would like to begin by objecting to the state's participation because they have not yet filed their appearance on this case since it has transferred from city court.
Okay, so you object to their participation. They're statutorily required to be here. The trial rules say they have to be here. So Mr. Poulos, I'm going to order you to remedy that by filing an appearance. Okay, what else, ma'am? So you want to be heard on your motion?
Yes,
Okay. So just so it's clear to me, I think is it just a motion to dismiss, but you filed it multiple times and maybe adjusted it a little bit?
well, I filed the initial renewed motion to dismiss, and then I filed a supplement, which was basically just more information, like arguments towards the original motion.
Okay. So just so it's clear to me and clear to the state, we're just here on a motion to dismiss. That's the only motion you filed
Right,
so far, right?
right.
Okay. So state, is there anything you want to talk about before we start?
No, Your Honor.
Okay, go ahead, ma'am.
Right. I come before you today, not just simply as a defendant, but as a citizen who has endured a series of avoidable wrongs rooted in procedural failure, retaliation, and silence. On the surface, this case may appear routine, but beneath that surface lies a chain of systemic breakdowns that have really no place in any courtroom, especially not one of any record. I am here today because I dared to speak up during a wrongful arrest of my husband, who was taken into custody based on a protective order that had been dismissed 2 years prior to this incident, which is, in my opinion, a failure in the prosecutor's office to update that dismissal, which triggered a cascade of injustice. And instead of being heard and explaining that, I was charged with a crime. I was not arrested at the scene. I was not cited. I was not even informed of the charge until 3 months later. And the case did not move forward because of clear evidence. It moved forward because an officer's word was taken without review of the evidence, and then mine was ignored. I'm in circuit court today because city court, which cannot legally conduct a jury trial, tried to keep this case in its jurisdiction until I had to personally request its transfer. For months, I have not only been defending myself against the charge, but against the silence, and silence from those who should have asked better questions, and who should have reviewed the evidence, and who should have known the law. I'm not here to posture. I'm here to ask this court to plainly look at the facts, the statute, and the record, and recognize the constitutional, statutory, and procedural failures that have accumulated. And I respectfully ask this court to dismiss this case with prejudice. The charge that I've gotten stems from just a simple traffic stop. And I was unlawfully requested to get out of my vehicle, and if I refused to do so, then I would be physically removed. At the time, I had tried to explain to the officer that he didn't have any reason to pull me over, because he had told me the reason he pulled me over was because I struck the edge of the roadway, which isn't even an infraction in the state of Indiana. And upon running my name and my husband's name, it was revealed that there was a protective order that was still active in the system that was supposed to have been dismissed 2 years prior to this incident, which I have required the paperwork via FOIA request, that the failure was to update that system was from the prosecutor's office. So my husband was unlawfully taken to jail that night. And when I was attempting to explain to them that this is all an error, is how I ended up charged with this. And when I was charged with this, I didn't even have any idea that I was charged with it. I was not even given a proper service of summons. I just received a paper in the mail that stated that this was set for an initial hearing. There was no proper service of summons like I had received for this court. I just feel that there's just multiple failures, and my rights to due process have been just trampled on this whole time, I feel. Pretty much all I got, I guess.
Okay, so here's what I'm gonna do. I'm gonna let the state respond. I'm probably gonna end up asking both of you some questions. So go ahead, state.
Your Honor, at that point in time, she actually listed what the reason for the dismissal would be, other than that she's upset with the process that's going on. While I understand it would be upsetting for her during her argument here at this point in time, Your Honor, all of her arguments she's made seem to be arguments that should be made at trial in front of a jury that she's requested at this point in time. In reviewing her motions, almost all of her arguments in the motions, alleged retaliation, violations of due process and procedural errors from the Knox City Court, regarding an illegal attempt to hold a jury trial. I'm still not really sure what her grounds for the dismissal would be at this point in time.
So what governs the motion to dismiss? Hang on. I'm gonna ask you next. I'm asking the state first.
Well, I'm not really sure what she's motioning to dismiss, Your Honor, besides just
The
case.
charges,
Yeah.
right? So obviously there's a standard I have to apply. What is the standard? Where does it come from? Is there a statute? Is there a trial rule?
One moment, Your Honor.
See if Ms. Risner knows the answer. Ms. Risner, do you know the answer?
I don't believe the state has the evidence to even,
Not what I'm asking. So is there a trial rule or a statute that governs motions to dismiss?
um. Motions to dismiss by defendant or IC 353414.
That's right.
The court may, upon motion of the defendant, dismiss the indictment or information upon any of the following grounds. The indictment or information or any count thereof is defective under section 6 of this chapter, which would also apply in this case.
All right, slow down. So you've identified the correct statute, which apparently the state didn't know about. So let's start with A1. So under A1, do you have anything that falls under that group?
Yes,
What would that be?
the indictment or information is defective
And you're saying it's defective how?
because on the criminal information, it states here that I was charged with under IC 3530 or 354513A1. Under the disorderly conduct statute, which that statute states engages in fighting or tumultuous conduct. Now, the
Okay,
language
so
or.
slow down. So you're saying that they've clearly cited the wrong law, right?
Correct.
Okay, so is there any other way you think it's defective other than that?
The facts do not, facts stated do not constitute an offense.
Oh, wait, we're still on one,
Okay,
right? So they've only charged you with one charge, right?
correct.
And you're saying the one charge they've charged you with, they've charged under the wrong statute. Okay, so under this statute, what's the remedy if they've done that?
It's.
I'm supposed to give them time to amend it, right?
Right,
Okay, so you've identified one problem. So let's go to two. What's two?
the indictment or information does not state the offense with sufficient certainty.
You may have an old version of the statute. So two, for me, A2 is misjoinder of the offenses.
Yeah, I skipped ahead.
Okay,
Okay, that's number 4, but
so you're not saying that you have anything in two, right?
correct,
Okay. 3 is grand jury proceeding was defective. That obviously didn't happen, right?
correct.
And then now you want to get to 4. So tell me, is 4 interrelated to 1? Is that kind of the same argument you're saying because they've cited the wrong statute?
Right,
They've not accused you of tumultuous conduct.
right.
Okay. And then what about 5?
5 would also factor in with that as well.
Okay. What about 6? You have immunity.
No,
Okay. Have you been prosecuted before?
no,
The prosecution is untimely brought.
I sort of feel like it is, yeah. I didn't get charged until 3 months after the fact.
You know what the statute of limitations for a misdemeanor is?
Yeah, it's like 2 years, so
Okay. What about 9?
no.
All right. 10.
Since we're no longer in city court, I don't feel like 10 would apply.
Okay. And then 11.
Um, well, there's a couple other numbers after 11. but towards the bottom of that, it says, motion to dismiss based upon a ground specified in subdivision A.
Well, then, so hang on, you're getting too far ahead. So 11 is any ground as a basis for dismissal as a matter of law. So do you have any argument on 11?
I would say, yeah,
Okay,
um. Given, the fact that it's, the whole charging instrument, I think, is just defective, so I think as a matter of law, that would be considered.
sure, but that's already identified. So this is saying anything. Do you know what you know what it means when it says as a matter of law?
Yes and no.
Okay, so I'll just explain it. So it means that there's no factual aspect, right? So like, for example, if they charged you 10 years after the offense occurred and it was a misdemeanor,
Right,
and there was no legal way for them to charge you that late, as a matter of law, I could just find, hey, it's been too long, right? So it doesn't involve facts, right?
right.
So do you have any legal reasons, purely legal reasons, that you think it should be dismissed? And I'm just letting you make your record here so they can respond since they didn't know about the statute.
Right, I mean. It's, given it's not under, any like statute of limitations or anything, I would just say. As a matter of law, yeah, I feel like it,
Let me try to move you along here a little bit. So all your other arguments involve facts, right?
right,
What witnesses are going to say, what you're going to say happened, what maybe other people are going to say happened, right?
right,
So those are all factual arguments that you may present at trial. You don't know how the evidence is going to turn out. Your main legal argument, what you're telling me that I'm hearing, and this is not me trying to put words in your mouth. I'm just trying to state it plainly so everyone knows, is you think the information is defective, right?
correct,
Okay. In your motion, you raise some other issues, but those other issues all depend on facts, right?
for the most part.
Okay. All right. So is there anything else you want to say before I turn it over to the state?
No,
All right. Do you want to respond now that Ms. Risner has pointed out the correct statute to you, Mr. Poulos?
Yes, Your Honor, an incorrect statutory citation will not mislead the defendant, or the charging portion of the information itself includes the essential elements of the charge. I understand her concern with the charge reading. I believe it says A1 at the very end where it should read A2. But the essential elements of what's alleged, as well as the factual basis which she's arguing against, she understands what the charge is, which is makes a reasonable amount of noise. I can't cite it specifically, Your Honor. I apologize for that. But the citation, or the criminal code citation, is off by one section from A1. It should just read A2. Disorderly conduct itself is cited, but that wouldn't be grounds for dismissal because the code is off by one number.
Well, sure. Wouldn't it be grounds for me to grant her motion and then give you a leave to amend it? And if you
Yes.
don't amend it, then we're done?
Yes, Your Honor.
Okay. Well, I mean, you could have amended it before today, right?
I thought I had amended it, but apparently I had not. Or I believe I may have amended it in the city court, but it didn't make it here.
Okay. So anything else, Mr. Poulos?
Nothing additional, Your Honor.
Okay. So here's what I'm gonna tell you, ma'am, and this is just me, trying to explain this to you the best that I can, understand that you represent yourself, is you've raised issues that are valid issues to raise at trial, right? Valid defenses to raise at trial, but today is not the trial. And you have to think about it this way too. What you said all these things, but none of that was evidence, right? Where everyone's going to hear about the evidence is going to be at trial. So I'm going to grant your motion to dismiss in part, indicating that there's defects in the state's information, and I'm going to grant them leave to amend that information. And then I guess here's what we're going to put in the order is how long is it going to take you to amend the information, Mr. Poulos?
1 hour, Your Honor.
Huh?
less than an hour.
So you want me to say that this gets dismissed if you don't amend it within an
I
hour?
would request to the end of the day.
Oh, the end of the day? Okay.
And I would object to his amendment due to the fact that he has had ample time from when this was in city court to amend it, because I had brought it up at the second pretrial conference that there was a defect in the charging instrument.
Okay, so what statute controls the amendments to the information?
Um, that would be IC 353415.
Okay, and what does it say?
An indictment or information which charges the commission of an offense may not be dismissed, but may be amended on motion by the prosecuting attorney at any time because of any immaterial defect, including miswriting, misspelling, or grammatical error, any misjoinder of parties, the presence of any unnecessary repugnant allegation, so on and so forth.
Okay. Right, and so it goes on to say that the only reason I can deny is if there's a finding that it substantially prejudices your rights, essentially, right, ma'am?
Right.
Right. And so I understand the nature of your objection, and I'm going to allow them to amend it because it is a very small amendment. I don't believe it's, prejudices you in any way. Now, if they tried to do this amendment at the last minute in the middle of trial, it may be different, especially if your defense is entirely built on the fact that they mischarged it. But you didn't raise the issue that way. You didn't wait until we were at trial to raise the issue that way. You raised it in the motion of defense to dismiss. And under the statutory framework, it's a notice pleading state. So defects in the information, unless they're dramatic or done at a very late period in the case, generally are not reasons to dismiss things or not allow amendments, because the whole idea is you're just supposed to be placed on notice about what the nature of the allegations are. I think it's clear for me. It's clear what they've alleged by the body of the charge. They've just put the wrong subsection in the statute. So Mr. Poulos has to the end of the day to amend the charges. If he doesn't, then I'll dismiss it. But if he files the amendment, we'll proceed forward on the amended charges, assuming the amended charges are right. So we need to set some dates. And then, so my question is this, ma'am, are you going to file any other motions we need to set hearings for, or do you just want to start the trial process? How do you want to proceed forward?
I guess we can just set some dates then.
For trial?
Yeah.
Okay. How many days do you think it will take?
Probably just one day.
1 day. So how many witnesses do you think you will call?
Just one right now.
One.
Unless I can.
And then state 2, 1.
2 witnesses, Your Honor. 1 day.
3.
Trial.
Oh yeah, that'd be half a day. And ma'am, you want a jury trial, correct?
Right.
Is August 20th too soon?
No.
No,
That's
stay.
It's fine, Your Honor.
Okay. Ma'am, how many, do you want to come back here more than one more time before the trial, or do you just want to come back one more time before the trial?
Yeah, let's do that.
Which one?
One more time.
Just one more time? Okay, so we're going to set just the final pretrial and state you don't have any reason to come back more than that, do you?
No, Your Honor.
Okay. So, and ma'am, I'm just going to explain this process just to keep this as straightforward as possible. If there's people you want to subpoena, in other words, there's people that you think are not going to voluntarily come down here with you, you need to file the paperwork for the court to send out the subpoena, since you're not an attorney, because you don't have the ability as a non-attorney to subpoena people, okay?
Right.
So you need to do that well ahead of time, and you need to make sure you have their correct information, and all that stuff. Because if you don't, and you subpoena the wrong person, or you don't have the right address, you know, that's kind of on you.
Right.
Just like it's just on the state if they do the same thing. So do you understand that part of the process? It's a little bit different for you because you don't have the ability to sign a subpoena, right? You understand that? Okay. So we're gonna set you for a jury trial, August 20th, 2025 at 9 a.m. A final pretrial. I don't want to set a mandatory pretrial. We're just gonna. No, you're right. She said she just wants to come back here one more time. So strike that date. So we're gonna come back for a jury trial, August 20th, 2025 at 9 a.m. and then a final pretrial plea agreement deadline and jury status conference on July 30th, 2025. I'm not gonna set any other dates before that. If there's some motion you want to file or you want a hearing, other than that, ma'am, just do that. But from what it sounds like, you've already kind of gone through the motions in city court. And if there's some other motion you want to file, we'll just set another hearing for you.
Okay,
There's an omnibus date of May 21st, 2025. You don't come to court on that date. It's just a deadline date for you as your own attorney to worry about, okay?
all right.
Giving questions, ma'am?
No, Your Honor.
Do you understand if you decided not to come to the trial, we could conduct the trial in your absence?
I understand.
All right. And do you understand if you fail to appear, it could also result in a warrant for your arrest?
I understand.
Okay. Say anything else?
No, Your Honor, thank you.
All right. Have a good weekend, ma'am.
Thank you.
Okay. All right. We're gonna go off the record for this a minute here.